Good day, Crime Talk aficionados. It is Monday, and we have a great show for you today. First on the docket, Barry Morphew enters a plea of not guilty regarding the case for, his dead wife. A surgeon has been arrested in connection with the double murder in Ohio. Jury selection is set to begin in the Fairfax County double murder trial. A day in the life of Nick Reiner. An update on the Uvalde School shooting case. Wait until you hear what a 5-year-old took to school. We've got this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that little bell for notifications, and remember, you can check us out on any of your favorite podcasting apps. Now, let me remind you, ladies and gentlemen, it is the start of the new year. You've been putting off all types of things that you needed to do. One is you're going to do a background check on all those people that maybe you just don't like. Maybe they're coming around your kids. Maybe you're not getting that warm, fuzzy feeling about them. You need to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do as many background searches as you desire while you have it. And remember, you can cancel at any time. So whether you want to do one search or 100 searches a day, it's all the same fee because it's a subscription. All right? You're going to get a report literally prepared while you wait. It's going to be emailed to you. You're going to find about phone numbers, social media presence, email addresses, criminal history, liens, judgments, married, divorced, criminal history, registration as a sex offender. Everything you want to know about somebody, you're going to be able to find out. Go to crimetalksearch.com, sign up today. You're going to be happy that you did. All right, let's go ahead and open the record for Monday, January 12th, 2026, ladies and gentlemen. And first on the docket, Barry Morphew. That's right. Barry Morphew appeared in court today and formally pled not guilty to the first-degree murder of his wife, Suzanne Morphew, who vanished back on Mother's Day in 2020. Now, a jury trial has been scheduled for October 26th. Now, though I haven't looked at the minute orders, he either told or waived speedy trial to accept that October date. Why? Remember, once you say not guilty, the state then has 6 months from that date to get you to trial, right? So January, so you got February, March, April, May, June, July. So October is outside the speedy trial date. Therefore, he would have had to waive speedy trial or toll speedy trial to accept that trial date, more than likely for scheduling issues for the attorneys. Anyway, the arraignment took place at the Alamosa County Courthouse, which is 40 miles south of Saguache County, where Suzanne Morphew's remains were discovered back in September of 2023. Now, obviously, this case has had a lot of attention and interest from true crime followers online, prompted by the court to impose strict limits on public access to live streaming proceedings after earlier hearings were recorded and shared without authorization. We told you all about that. There was that JR Investigates guy. Clearly states when you sign into the Colorado website, when you view cases, that you cannot stream, you cannot record it, you can be held in contempt. Well, the court said, hey, there are a couple of bad actors here. And instead of punishing those bad actors, because, well, really, they're in a different state, it's going to be really difficult for me to get them here, I'll just punish everybody so that you can't watch the proceedings live. And they're going to limit us to actually stream them as well. So just remember, ladies and gentlemen, when you mess up, you affect everybody in that regard. And if it says don't do it, well, do you really want to blow it and be held in contempt? Probably not. Anyway, Morphew, who is free on a $3 million bond, attended the hearing, obviously in civilian clothes because he's out of custody. Now, his attorney, David Beller, a guy that I know, entered the not guilty plea on his client's behalf and requested a waiver of the statutory right to the trial within 180 days, 6 months. And Beller explained that the volume of discovery material in this case and the anticipated length of the trial made it impractical to proceed within that time frame. Now, Morphew confirmed to the judge that he understood that he has a right to that trial within 6 months and agreed to the waiver. Now, this marks the second time that Mr. Morphew has faced murder charges in connection with his wife's death. He was initially arrested back in 2021 by then 11th Judicial District Attorney Linda Stanley, who gave a masterclass in malpractice, which got her disbarred, and some of her other attorneys sanctioned by attorney regulation. Ultimately, those charges that Ms. Stanley brought were dismissed without prejudice back in April of 2022, shortly before a trial was to commence. And like I said, the prosecutor screwed it up, and they failed to meet court-ordered deadlines as it relates to Suzanne Morphew body that had not been yet located at that time. There were lots of discrepancies. And they also tried to go after a judge because they didn't like the rulings that they got. It was amateur hour. So like I said, Stanley was disbarred in 2024 in regards to her management of the Morphew prosecution, citing as the significant factor. Among the ethical violations were unauthorized media interviews with true crime content creators, and an attempt to investigate the presiding judge over unfavorable rulings. And yes, one of those interviews that she actually did was with Mike King of Profiling Evil, and I couldn't believe that she was saying what she did on that show. He actually testified at her disciplinary hearing. Anyway, the investigation advanced significantly back in 2023 when the state police actually located Suzanne Morphew's remains during an unrelated search south of Moffat County. Anyway, a 2024 autopsy revealed traces of an animal tranquilizer known as BAM in her system, a substance that investigators say that other than maybe a few vets in the entire western portion of the United States, the only other person that had that was Barry Morphew, and he had access through his work. Now, following a grand jury indictment, Morphew was rearrested in Arizona in 2025, ultimately extradited back to Colorado. He secured release after posting the $3 million bond with the assistance of a bail bond company and supporters. Now, the couple's two daughters supported his pretrial release, and Morphew provided substantial cash collateral. His legal team has declined to disclose the origin of those funds. Now, what's interesting in that regard is, listen, his attorneys were originally court appointed. Mr. Beller and his co-counsel. But obviously, if you can post a $3 million bond, you're not indigent. So he has since retained them. And the filing that Mr. Beller put with the court was, hey, Judge, we're no longer court appointed. When the money runs out, we'll let you know, and we'll ask to be court appointed again. Now, he didn't say those exact words, but that's really what he said. Because if you can afford a $3 million bond, you can afford to pay your attorneys. So anyway, the case now proceeds under the new prosecutorial team, with trial preparations expected to extend over the coming months. It's going to be an interesting case, ladies and gentlemen. I see this one going to trial. I do not see any kind of a guilty plea in this particular case with Mr. Morphew, unless it is such a smoking good deal that he cannot turn it down, like some sort of, reckless manslaughter, which would be, I think, a class 4 felony, 2 to 6, maybe credit time served or something along those lines. But I doubt it. Guess is, if there's going to be an offer, they would make an offer of second-degree murder, which would be 16 to 48. And when you're 50-something years old, it's a life sentence anyway. So my prediction is this will finally go to trial unless the prosecution screws it up like they did last time. Let's hope they get it right. Next, a surgeon has been arrested in connection with the double murder in Ohio. Police have arrested the former husband of a woman killed alongside her current husband in Columbus last month. They charged him with 2 counts of murder. Please meet Michael David McKee. This guy's 39 years old, and he's a vascular surgeon based in Rockford, Illinois, and he was taken into custody Saturday in Illinois. Now, the court records indicate he faces murder charges in Ohio related to the death of Spencer Tepe and who's a dentist, and his wife, Monique Tepe. Now, the Tepes were found shot to death in their Columbus residence on the morning of December 30th, following a welfare check prompted by concerned friends and colleagues. Police reports state that Spencer Tepe sustained multiple gunshot wounds. The couple's 2 young children were present in the home at the time, but they were discovered unharmed, which is good. The dog was apparently there as well. Anyway, the investigators estimate the killings occurred between 2 a.m. and 5 a.m. that day. Now, prior to McKee's arrest, the Columbus Police Department released surveillance footage showing an individual in a hooded jacket walking through a snowy alley near the Tepes' home during the early morning hours, believed to coincide with the crime. Now, McKee and Monique Tepe were married back in 2015 and divorced in 2017. And public records show that McKee has resided in several states, including Virginia, Nevada, and Illinois since 2020. The investigation remains ongoing as Mr. McKee awaits extradition in Ohio. Now, we are not saying that Mr. McKee should not be given the presumption of innocence. He should, absolutely. Now, there's also some, we have that video. Doesn't show his face, but, kind of looks like him. And what are the odds that he just happened to be there? My guess is they'll have cellular data. My understanding, they also have information from his car and items of evidentiary value found in the car as well. Apparently, family members were saying, hey, you should go talk to this McKee guy. Now, what would make 39-year-old vascular surgeon who's probably pulling in a cool $1 million a year, working a couple of hours a week, to go and ruin his entire life to go kill his ex-wife and current husband? What on earth would make you want to do that? I guess he just never got over it. I don't know. It's going to be interesting to see where that goes. For the meantime, we'll give Mr. McKee the presumption of innocence. Perhaps he has a good alibi, which I'm sure the police probably checked out any possibilities of alibis, but it's going to get good for sure. Next on the docket, jury selection begins in Fairfax County. That's right, ladies and gentlemen. Jury selection commenced today in the high-profile trial of Brendan Banfield, who faces 2 counts of aggravated murder in connection with the February 2023 deaths of his wife, Christine Banfield, and Joseph Ryan at their Herndon, Virginia home. Now, the case, which has drawn significant attention, centers on allegations that Banfield collaborated with the family's Brazilian au pair, Juliana Perez Magalhães, to stage the killing as a home invasion. Now, prosecutors contend that Magalhães has been romantically involved with Banfield, playing a role in the homicides. Now, she has since pled guilty to a reduced charge of manslaughter and is expected to testify for the prosecution. Now, obviously, there's been a lot of media coverage on this case, and it's going to complicate the jury selection process, but don't worry, they will find one. Well, Madeline Somerville, a CEO of Georgia Trial Consulting, she has stated in some opinions that, so obviously in high-profile cases, there's always the potential that jurors often encounter specific evidence or details throughout news reports and from opinions before the trial begins. However, that's what the voir dire process is for, ladies and gentlemen. Obviously, jurors are required to base their decisions based upon legally presented and competent evidence presented in court. It doesn't matter what they heard outside the courtroom, read in the paper, saw online. It doesn't matter. That's the whole process. Now, everybody gets all excited saying, oh my gosh, it's a high-profile case. We're not going to be able to find jurors. Show me a case where we haven't been able to find jurors. Most people live under a rock, ladies and gentlemen, and they could care 2 cents. Most people could care less about what goes on in their community most of the time, even in a high-profile murder case. I guarantee you there are people that just don't care. And if they're willing to serve on the jury, to reserve judgment until they hear all the evidence in the case, follow the court's instructions, they are a qualified juror. That's it, right? Be fair and impartial to both sides. Listen to all the evidence, legal and competent evidence that comes in through evidence, through exhibits, physical evidence, testimony. That's evidence. Reserve judgment till they hear all the evidence, and then follow the court's instructions, right? Apply the facts to the law, Did the prosecution prove their case beyond a reasonable doubt? They will be able to find 12 competent jurors. So everybody always gets spun up. We're never going to find jurors. Oh my goodness. Yes, we will. And the worst case scenario is you move it to a different city, and guess what? Another county, and you're going to be able to find jurors. It happens all the time. Most people just don't care. Anyway, the trial, expected to last approximately 4 weeks, will take place at the Fairfax County Courthouse. While the prosecution's narrative has been outlined through their prior proceedings, the defense approach and Banfield's response to his former au pair's testimony, well, that remains undisclosed. Let me tell you what that testimony will be, ladies and gentlemen, or the cross-examination to that testimony of the au pair. Liar, liar, pants on fire. You would say anything you could to get out of trouble, and you didn't want to do it. In fact, because you're the one that committed the crime, and you're just trying to throw him under the bus. How dare you, ungrateful au pair. We bring you here from Brazil, and this is how you treat us. That's going to be the cross-examination, ladies and gentlemen, trying to raise reasonable doubt. Anyway, the outcome of this case is going to hinge on the jury's assessment of the evidence presented during the proceedings as the community awaits further developments in this closely watched trial. Next, how about a day in the life of Nick Reiner? I know, doesn't everybody want to know what Nick Reiner's doing? For those who don't know, Nick Reiner, the son of filmmaker Rob Reiner and producer Michelle Singer Reiner, has been held in solitary confinement in a high observation mental health unit at the Twin Towers Correctional Facility since his arrest back in December, specifically December 15th of last year, on suspicion of murdering both his parents. Now, according to multiple law enforcement sources who spoke to the press, Reiner is housed alone in a 7 by 10 foot cell in Tower 2, a unit reserved for inmates with serious mental health conditions that require isolation from others. Medical staff have determined that he has a mental disability and he remains under close supervision. Now, Reiner receives 3 meals a day delivered directly to his cell. Breakfast is served at about 6 a.m., lunch at 10:30, and 11 a.m. Dinner is at 5 p.m. Now, breakfast and lunch consist of cold items, while dinner is typically a hot meal. And people describe the menu in this unit as superior to that of the other Los Angeles County jails. He's given approximately 1 hour to eat before a deputy collects the tray. And then on January 7th, Reiner's routine was briefly interrupted for his arraignment. And earlier that morning, after receiving clearance to appear in court, he showered and changed into a prison-issued brown jumpsuit. He was then transported to the marked law enforcement car to the Clara Shortridge Foltz Criminal Justice Center. Following the hearing in which no plea was entered, his defense attorney withdrew from the case and he was returned to the Twin Towers and resumed his standard schedule, eating dinner alone under fluorescent lighting while wearing a bright yellow short-sleeved jail shirt and dark blue pants. Now, Reiner is apparently no longer on suicide watch and is not required to wear the suicide prevention smock. However, he continues to be monitored every 15 minutes and is recorded whenever he leaves the cell for a court appearance, some other type of evaluation, or other essential purpose. Now, he receives weekly assessments from on-site psychiatrists and other medical professionals. Yes, because they are the ones responsible for getting his medications correct, so that they can say that he is competent to proceed to trial. Anyway, obviously this case still under further investigation, even though he has been arrested and charged. And obviously Reiner is waiting for further court proceedings because his new attorney, the public defender, had to jump in after Alan Jackson got off the case because Mr. Green didn't show up. When Mr. Green doesn't show up, you got to get off the case, just the way it is. No one's going to do a death penalty case or a not guilty by reason of insanity case pro bono, free of charge. Not going to do it. Who's going to pay for those people to get their services paid for? Well, apparently not the Reiner family. Next, how about a quick update on the Uvalde school shooting case involving a police officer? So today, testimony from the Texas Rangers and other law enforcement personnel dominated the 6th day of the trial of former Uvalde Consolidated Independent School District police officer Adrian Gonzalez, who faces charges of child endangerment and abandonment stemming from the law enforcement response to the May 24th, 2022 mass shooting at Robb Elementary School. Now, the attack claimed the lives of 19 students and 2 teachers. Now, Gonzalez was indicted back in 2024, and his trial was moved to Corpus Christi for change of venue reasons, because obviously he wouldn't get a fair trial in Uvalde. And coincidentally, they were able to find 12 disinterested people to listen to the evidence. Amazing how that works, isn't it? Anyway, the former Uvalde police chief, Pete Arredondo, faces similar charges, but his trial date remains unscheduled. Now, proceedings on Monday today featured detailed accounts of the crime scene investigation and continued debate over standard active shooting protocols and tactical decision making. In the morning session, the day opened with continued testimony from Texas Ranger Terry Schneider, who described his role in evidence collection and victim recovery. Schneider explained how cartridge casings were documented in the school hallway and confirmed that the shots had been fired in the east hallway. Defense questioning focused on tactical considerations, including the concept of the fatal funnel, a high-risk area of exposure for officers advancing towards gunfire, and whether returning fire based solely on sound would be appropriate. After a mid-morning recess, the Texas Ranger Scott Swick took the stand. Swick, trained in bloodstain pattern analysis, detailed his examination of classroom 111 and 112. He described dozens of spent cartridges, multiple empty 30-round magazines, bullet trajectories through the walls, backpacks, and classroom fixtures, as well as damage to door locks and window blinds. Now, defense cross-examination emphasized that the classroom doors' locks showed no sign of forced damage and revisited officers' safety concerns in the fatal funnel theory. Now, the afternoon session following the lunch recess, Texas Ranger Robert Montalvo Jr. testified about the arrival at the scene and subsequent duties, including evidence management at the Uvalde Memorial Hospital, where he encountered the bodies of 2 deceased students, Jacqueline Gazares and Jose Manuel Flores Jr. Graphic autopsy images of the children were shown to the jury, along with evidence of a Hellfire trigger device recovered from the shooter's weapon, a modification that increases the rate of fire for semi-automatic rifles. Now, questioning centered heavily on active shooter response doctrine, and prosecution inquiries pressed Montalvo on whether Gonzalez adhered to the principles of isolate, distract, neutralize. The threat, that is. And Montalvo indicated that there was no evidence that Gonzalez followed that protocol. Defense counsel explored chain of command obligations, the priority of stopping the killing above all else, and the practical dangers of creating crossfire or entering high-risk areas without clear knowledge of the shooter's location. Now, throughout the day, the defense attorneys repeatedly highlighted the chaotic acoustics caused by echoing gunfire and the tactical challenges officers face in determining the shooter's exact position. Family members of the victims, including relatives of Tess Mata and Jacqueline Cazares, attended the proceedings. The judge presided as both sides continued to examine the actions or inactions, in this particular case, of the responding officers during the 77-minute period between the shooter's entry into the classrooms and the eventual breach by a Border Patrol tactical team that was like, let's go, guys, let's roll. Anyway, the trial is expected to continue with additional witness testimony over the next several weeks. Next, wait until you hear what a 5-year-old took to school. And we're going to learn that a 50-year-old man was taken into custody after a loaded 9mm handgun was discovered in his young son's backpack during school hours at the elementary school that he attended. Now, the incident occurred on Thursday, January 8th, when the school staff found the firearm inside the 5-year-old student's backpack. Cape Coral Police Department officers responded promptly and secured the weapon. According to police, the child stated that he had no knowledge of the gun's presence. Detectives from the Violent Crime Unit subsequently interviewed the parents. The father, identified as James E. Wilson IV, acknowledged placing the loaded handgun in the backpack temporarily while intending to move it to his vehicle. Now, a police spokesman emphasized that the investigation determined there was no intentional threat to students or staff at the school. The backpack was opened, the firearm was observed and thoroughly inquiry followed thereafter. Anyway, at no point was the student or any student in danger. Needless to say, Mr. Wilson was arrested and charged with child neglect and improper storage of a firearm based on probable cause established by the investigation. Obviously, lots of concerns here about firearm safety and access in households with small children. It's not like the child in this particular case was opening drawers and say, I'm going to take this to school to show to my buddies. He didn't even know it was there. Dad, what are you doing? I mean, I'm usually not a big fan of trying to hold the parents responsible for what the kids do. But in this particular case, the kid was 5 and you said you put it in his backpack thinking you're going to later move the gun to your car. Well, guess what, sir? My guess is your days of perhaps carrying concealed are over because, well, you don't show the good judgment that one would normally hope that a gun owner would have. Anyway, no other details at this time. Next on the docket, this day in legal history. On this date, January 12, 2007, Public Law 109-476 was approved, targeting the unlawful acquisition and misuse of consumer telephone records, including pretext tactics and strengthening privacy protections. It's a notable federal response to modern data records abuse. Now, as you may recall, I when I was going through, I see this, I'm like, I remember that because back during that time, ladies and gentlemen, somebody could call up and the people were making lots of money. Oh, you want to get your wife's cell phone records? You want to get your boss's cell phone records? You hired a private investigator. He would then send a request or call, and they would then send the phone records to whoever requested it. Now, they were probably doing something unethical, but at the time, I represented several clients that got sued, and they were supposed to go testify in Texas. We were able to resolve it by saying we were going to stop doing that, or the client was going to stop doing it. I never did it. But the point is, it used to be pretty sneaky what people would do, and people would pay big bucks. I mean, it was literally like, hey, I'd like to get my phone records. What's your cell phone number? Here it is. We're going to send it to you. Boom. And these people were charging at the time hundreds of dollars, and they were doing literally thousands of orders a day, and people wanted them for every month. It was crazy. Now you just got to go to crimetalksearch.com and find out what you can. On this day, January 12, 1999, Buckley v. the American Constitutional Law Foundation. Well, the Supreme Court invalidated several Colorado restrictions on petition circulators, treating the petition process as core political speech. It remains the leading case on the constitutional limits of regulating ballot initiatives, right? So if you know about ballot initiatives, you have to go out and get a certain number of signatures of qualified voters. You know, the people standing out there, and they have you sign it, and then ultimately they go back and they check it to see if you're a valid registered voter. Anyway, the state hates these petition process, even though it's the core of democracy, right? So they put all these crazy restrictions on them. Oh, you can't do this, you can't do that. The people collecting signatures can only be 6'3" or taller. It was ridiculous restrictions. Supreme Court struck it down, said no, just collect the signatures and we'll deal with it later. Next, our quote of the day. One prominent legal quote addressing mental health issues appears in the United States Supreme Court decision of O'Connor v. Donaldson. 422 United States Supreme Court Reporter 563, decided in 1975. It's a landmark case concerning the constitutional limits on civil commitments of individuals with mental illness. It's one of the cases that led to all the problems that we have now with people with mental health issues, ladies and gentlemen. Quote, a finding of mental illness alone cannot justify a state's locking a person up against his will and keeping him indefinitely in simple custodial confinement, end quote. Obviously, this ruling established that the non-dangerous individual with mental illness who are capable of surviving safely in freedom independently or with support cannot be involuntarily confined solely on the basis of their mental condition. This decision underscores protections under the Due Process Clause against unjustified deprivation of liberty. Interesting, isn't it, ladies and gentlemen? That's where we are today. Remember, they used to have, right? Remember, you see all these old movies? They used to have mental health wards. People went to the state health hospital, right? Remember One Who Flew Over the Cuckoo's Nest? And if you had a mental health issue, they just put you there, right? They didn't have the medicine. They didn't know what to do with you. You couldn't live and function in society. They did that. And then in one of these cases, and one shortly thereafter, ACLU sues, says you got to get everybody out of the mental health wards, even if they're going to be homeless, as long as they're not dangerous, you can't keep them there. I understand it, both sides. They're not hurting anybody that's really what our fundamental principle of our justice system is, hey, as long as you keep to yourself, you don't bother anybody, we're not going to take away your liberty or freedom, unless, of course, you violate somebody else's liberty or freedom and assault them and murder them or rob them, right? That's the role and duty of the state, is to protect your rights and then to punish the people that have violated your rights to live peacefully and freely. Something to think about. Tough issue, probably not going away anytime soon. And then finally, our dumb criminal of the day. Once again, going to Florida. That's right. A 23-year-old Safety Harbor man who attempted to orchestrate seemingly coincidental meetings with a former romantic interest by secretly attaching a GPS tracking device to her vehicle has resolved the resulting criminal case with a no contest plea to a reduced misdemeanor charge. Please meet Tyler Strack, our dumb criminal of the day. He entered a plea in court on January 8th, avoiding a felony conviction. He was sentenced to pay approximately $700 in fine and court costs, with the option to offset the part of the amount through community service, credited at $14 an hour. I'm not even sure that's minimum wage. Anyway, according to court records, the case began last year when the 22-year-old victim discovered an unfamiliar device on her car parked outside her residence. She reported it to police, who traced it, the little Cube brand tracker purchased at Best Buy, to Strack through subpoenaed transaction records. When questioned by investigators, Strack admitted he had placed the device in hopes of timing, quote, chance, end quote, run-ins with the woman with whom he had shared a brief relationship several years earlier that ended without further contact. Anyway, prosecutors initially charged Strack with a felony offense related to the unauthorized installation of a tracking device, which is a crime in most jurisdictions, ladies and gentlemen. You can't track people without their knowledge. Anyway, the reduction to the misdemeanor reflects the resolution, obviously, of a plea agreement. Now, at the time of the arrest, Strack was employed as an assistant manager at Chipotle restaurant, and efforts to obtain comments from Strack following the plea, well, unsuccessful. Perhaps he'll just have a chance meeting with somebody from the news media. Anyway, listen, ladies and gentlemen, a little bit of a reminder, legal boundaries. Boundaries are good, all right? You cannot surveil people that don't want you to follow them. You know what they call that? They call that stalking, all right? So don't plant little GPS monitoring devices on people that don't give you permission to do so. That's stalking. Anyway, Mr. Stark, you are a dumb criminal of the day. Congratulations, you made it. One of many for the year to come, but you did it early on. Congratulations. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time. And remember, the Constitution matters.